apologize in advance about how hot it is in here. Please don't trip over all of the cords. We brought in some fans to try and keep the temperature down. So I apologize about that. So I'm here today to present on INRAE IC, and I promise it's not going to be another D training. I know I did one last fall. This is more of a follow-up to that, a review of the case law leading up to INRAE IC and focusing solely on Lucero-L indicia of reliability. So it's different. You aren't going to sit through the same training, I promise. And just to keep a framework of where we are during this process, all of these cases deal with an adjudication of a WIC 300D petition. So all of the case law is in reference to an adjudication, sex abuse. So that's kind of where you need to keep your head at when we're talking about the various case laws that we are addressing today. The goal of today's training is to know how and when to apply Lucero-L, the effect that Lucero-L has on our practice, and why we care about Lucero-L and INRAE IC. I have a little bit of 355s woven in, just kind of out of necessity, but we do have a totally separate training focusing solely on WIC 355 coming up in September, so stay tuned for that one. So kind of just to start things off and give everyone a frame of reference of what we're dealing with and what we're talking about. California Evidence Code Section 1200 says that an out-of-court statement offered to the truth of its contents is inadmissible in evidence. Asterisk next to that, except in dependency court because we have special rules. So that's what we're going to be discussing today. The hearsay rule is rooted in concerns of reliability. Unlike in-court testimony, hearsay statements are not made under oath. They are made outside of the view of the prior facts, so the judge is unable to assess the speaker's credibility, their demeanor while testifying, and they are not subject to testing through cross-examination. So that is kind of the basis for the hearsay rule. So moving into the dependency case law, we are in 1990, Melinda S. Anyone care to guess what Melinda S. is about? Sex abuse. It's a bad case for us, so of course it's about sex abuse. So the facts of Melinda S. Mother was bathing her 4-year-old child. She noticed a strong odor coming from the child's vaginal area. Mom says, "You need to wash your privates." Child says, "Nope, I'm not going to do that, it hurts." Mom says, "Well, why does it hurt? What happened?" And the 4-year-old child says, quote, "Because my daddy has been touching my privates." DCFS gets involved. The child then recants. It's pretty clear from the facts that everybody thinks that this is because of coaching by the paternal great-grandmother, that the great-grandmother was trying to get the child to recant her statements. There were actually multiple witnesses called in the adjudication in Melinda S. The mother was called, the paternal great-grandmother, and the social worker. The child was not called, and the father, who was the alleged perpetrator, was not called as a witness. However, the issue that went up on appeal after the court sustained the sex abuse allegations was, are these social study reports that the social worker is submitting, and then the hearsay within those reports, competent evidence to support a finding of jurisdiction under WIC 300. So the Court of Appeal says yes. Dependency is special. There are special evidentiary rules for dependency court proceedings, and given that there is a statutory provision authorizing juvenile courts to consider these social studies, these DCFS reports, that statutory provision therefore implicitly creates a hearsay exception to any of the hearsay statements contained in those reports. And the statutory provision that they are referring to is WIC 355. So that's 1990, Melinda S. Then we fast forward to 1996, and the legislature, due in part to Melinda S., then amends WIC 355. And when WIC 355 was amended to codify the admittance of those hearsay statements of a child victim contained in the DCFS report. So now we have this amendment to WIC 355, and I put it for you as WIC 355 C1B, which says that if a party raises an objection to a hearsay statement in the report, aka by filing your 355s, then that hearsay evidence alone is not going to be sufficient without corroboration to sustain the allegation and find jurisdiction. Specifically, unless any of the listed exceptions in WIC 355 apply. One of those exceptions is if the child is under the age of 12 and is the subject of the petition, those statements are coming in unless we can show that they are the product of fraud, deceit, or undue influence. All of this is taken directly from WIC 355, so it's directly from the statute. So we then come to Cindy L., which is a case from 1997. The original case that actually created the first child hearsay exception in the context of sex abuse cases specifically was Carmen O. That was a 1994 case. And unlike Cindy L. and Lucero L. and In Re IC, the child in Carmen O. was actually truth competent, so they were able to distinguish between the truth and a lie. The issue with the child in Carmen O. was she was unable to testify because she was intimidated by the courtroom setting. So Carmen O. was the first case to create this child hearsay exception, which we're going to be talking about for the remainder of this training. So we get to 1997, Cindy L. In Cindy L., this dealt with a child that was actually only 2 years old. This child was about to turn 3, so she was 2 years old. She was at daycare. She was observed to be touching herself during nap time at daycare. When confronted by the daycare teacher, the child said, quote, "Daddy always touches me right here," and referred to her vaginal area. The mom confronted the child denied the sex abuse when the mom spoke with her. Then we have a second incident at the preschool where the same thing happened, and at this point the preschool then calls DCFS gets involved, children's court case is filed. And throughout the investigation, the child disclosed sex abuse to the social worker and to the police, in addition to the daycare provider, where she already disclosed sexual abuse. In Cindy L., there were some physical findings that were consistent with the child being sexually abused. And when she was called to testify at trial, when the child was asked if anyone touched her pee-pee, she responded, quote, "The clown." So, based on what happened at trial and her statements at the adjudication, the court found her truth incompetent. That means she does not know the difference between a truth and a lie. In Cindy L., the court let her statements in that were in the DCFS report, sustained the petition. Dad, of course, the alleged perpetrator, appeals. So the court in Cindy L. created an exception to the hearsay rule, specifically in dependency proceedings, where out-of-court statements of a child who are the subject of the petition are admissible if these statements have the required indicia of reliability, which we'll talk extensively about in a minute, if the statements are either corroborated or the child is available for cross-examination, and notice is provided to all parties that these statements are going to be used, even if the child is found incompetent to testify. So this is known as the child hearsay exception. And interestingly, the WIC 355 statutory amendments were noted in the Cindy L. opinion, but they weren't addressed because the events at issue in the Cindy L. case happened before the legislature made the amendments to WIC 355. So, again, now we have WIC 355 that says if the child's under 12 and this child is the subject of the petition, these statements are coming in, period. And they can be the sole basis of jurisdiction unless we establish that they're the product of fraud, deceit, or undue influence, in which case they aren't coming in at all. So, this leaves us with a conflict in the law. We have case law that says these statements can't come in unless these certain requirements are met. Notice, indicia of reliability, and the statements are corroborated. And then we have a statute, with 355, that says, yeah, they're coming in and they can be the sole basis of jurisdiction without any of that. So that leads us to Lucero L. And so fast forward to 2000 is when Lucero L came out. It was the first case to address this conflict between WIC 355 and Cindy L. So the facts of Lucero L. Lucero was detained originally in 1994 due to allegations of sex abuse of her older half-siblings by her father. That petition ended up getting dismissed because the half-sisters recanted. They said, you know, we just wanted our stepdad out of the house. He's really strict. We didn't like his rules. We wanted him out, so we made these allegations up. Then fast forward 3 years later, 1997, there are again allegations of sexual abuse by the father. When the half-sisters were interviewed for this second dependency case, they said that the only reason they recanted back in 1994 was because mom pressured them to. When Lucero was interviewed by the social worker, the police, and she made statements to her foster mom regarding the alleged sex abuse. There was a forensic exam that was completed that was inconclusive, meaning it couldn't confirm or negate that sex abuse occurred. At trial, Lucero couldn't qualify to testify, so she was truth incompetent, didn't know the difference between a truth and a lie. And interestingly, the trial court ruled that Lucero's statements were inadmissible under the Cindy L criteria because they were uncorroborated. But her statements in the reports were admitted under WIC 355. So we have this like wacky situation where under one rule, these statements were inadmissible, under another rule, they came in. So Dad appealed, and this issue came up in Lucero L for the first time. So what were Lucero's statements? Lucero was not very verbal. She didn't really use complete sentences. She would basically just say, you know, someone would ask, she'd say like, Poppy owie. And someone would say, where's the owie? And she would say, not here, put her hand in her vaginal area, bend over, indicate her rectal area, and say, here. Here, owie, Poppy owie. So she wasn't very verbal. She wasn't able to really verbalize these alleged incidences of abuse, but she was consistent in her statements to various people when she was interviewed. Lucero was 3 years old, and in the police report, the police specifically indicated that the child was very hard to understand. She had some speech issues, and the police indicated that it was unclear whether or not she knew the difference between a truth and a lie. So the court obviously sustained these allegations, and then we got Dad appealing. So in Lucero L, the issue was whether or not these statements contained in the reports from DCFS alleging sex abuse by this 3-year-old truth incompetent child are admissible, and if so, can they be the sole basis of jurisdiction? Because we have nothing to corroborate what this child said because the forensic exam was inconclusive and there weren't any other witnesses to this abuse. So Lucero L court said, yes, statements made by a child in DCFS reports are admissible under WIC 355 even if the child can't distinguish between a truth and a lie. However, those statements can't be the sole basis of jurisdiction unless they have sufficient indicia of reliability, which I'm going to be repeating over and over, and we'll go into that in a second. So it's kind of crazy because the court is saying these statements that are made by a child who has no idea what the truth and what a lie is can be the sole basis of jurisdiction against one of our clients if they meet this indicia of reliability. So the court said that these indicia of reliability are, number one, the spontaneity and consistent repetition of the statements by the child. Number two, the mental state of the declarant. Are there any mental health issues going on? Three, the use of terminology unexpected for a child of similar age. Four, lack lack of motive to fabricate. Is this a family law case? Are the parents embroiled in a custody battle? Maybe is there coaching going on? Truth and competency is a factor but not dispositive, which quite honestly to me doesn't make sense, because you don't get to Lucero L if you have a child who knows the difference between a truth and a lie. You only get to Lucero L if you have a truth and competent child, so anytime you're doing this analysis, yeah, this child's going to be truth and competent. But the court did list that as a factor. They also said that this is not an all-inclusive list. You can include anything else, any special circumstances surrounding this case and these disclosures of abuse. In Lucero L, the court specifically said that the corroboration requirement referenced in Cindy L was a judicial construct, it's not necessary under the statute, and it's not required by due process. So when we go through the indicia of reliability in Lucero L, number one, spontaneity and consistent repetition. This is argued by the court to have been met here. This child made these statements to the social worker, to the police officer, and to her foster mom. Number two, mental state of Lucero, the declarer. She was very young, but she didn't have any known mental health issues. Number three, use of terminology unexpected for a child of similar age. Lucero used age-appropriate terminology like pee-pee, cola, owie. What's interesting is the court in Lucero L noted a different way of phrasing this is that they said that it could be the precociousness of the child's knowledge of sexual matters. So does this 3-year-old seem to have some sort of knowledge about sex that a normal 3-year-old would have or not? Number four, motive to fabricate. Here, there wasn't any custody battle or anything else going on. There was no given motive for Lucero to lie in this case. Obviously, Lucero is truth and competent because, like I just talked about, you don't even get to this if you have a child who knows the difference between a truth and a lie. And then the court said, again, anything else. We can use anything else. The court in Re IC said that the unifying principles among all these different indicia of reliability factors are they relate to whether or not the child declarant was particularly likely to be telling the truth when the statement was made. So that's kind of what all of these different factors go to. So you're probably like, this guy, like, what? And? So basically, what all of this means is when you put together WIC 355, Cindy L, Lucero L, we kind of have these different principles. Hearsay statements of children under the age of 12 are coming in, period. They are coming in unless we can prove that they are the product of fraud, undue influence, deceit, etc. So unless we can prove that, those statements are coming in. They are coming into evidence, there's no keeping them out. However, they can't be used as the sole basis of jurisdiction unless you have this sufficient indicia of reliability when the child is truth incompetent. An interesting thing to note is this quote from Lucero L. It's actually a quote from a different case, but Lucero L quoted it, and In Re IC also quoted it, so it's kind of important. Admissibility and substantiality are different things. So yes, the statements are coming in, but that doesn't necessarily mean that they are sufficient enough to sustain the petition. When you have hearsay statements of a child over the age of 12, you have to meet the WIC 355 standards. So they have to be available for cross, or their statements have to meet a hearsay exception. And then just something to keep in mind in general, child hearsay exception from Cindy L. It can be argued technically to admit statements of a child in any context if the Cindy L criteria are met. So not necessarily sex abuse cases, it could be other cases. Lucero L, same thing. If you have a truth incompetent child making statements, oftentimes, yes, it is a sex abuse case, but it doesn't have to be. It could be, for example, a physical abuse case. So keep in mind, we talk about Lucero, we talk about indicia of reliability strictly in the context of sex abuse cases because that's 99.9% of the time how it pops up, but it's not limited to just child sex abuse cases and 300D petitions. So all of this up here and everything in the slides is also reflected in the flowchart. So if you get a Lucero L, not even a Lucero L, just a child who's making hearsay statements, you can use this flowchart to kind of figure out where you are those statements coming in or not, and what the various citations in the law are to back up your arguments. So, this is kind of how I feel about all of these cases. Like, why? Why do we have all of these exceptions? Why do these rules totally suck for us? Court of Appeal, why are you making our job so difficult? Guess what? They address that in their opinion. And they say that this is a balancing act between the need to protect the child from abuse and the parents' due process rights to custody and to raise their child. So Cindy L. addressed this specifically and indicated that in the context of child sex abuse cases in particular, there's frequently a lack of physical evidence. The child oftentimes has a limited verbal and cognitive ability. The child is often unable or unwilling to testify and act as witnesses. They can be intimidated by their parents, by the courtroom setting. So all of these are the reasons why the court came up with these special rules for dependency court proceedings, particularly in the context of sex abuse cases. All right, so I've done a lot of talking about things that are not the title of this presentation. I know you're all anxiously awaiting to hear about In Re IC. So now that we have the framework with WIC 355, Cindy L, Lucero L, fast forward to this year, 2018, and Lucero L appears again with a vengeance in Re IC. So our players are IC, the subject child. She's 3 years old. Her brother, JC, is 5. There is the sex perpetrator neighbor, Oscar, who's 8. And then there's an adult sibling of IC and JC. She's RJ, she's 21. The allegation in Re IC is of child sex abuse by IC, or of IC by the father, placing both IC and JC at risk of harm. And we are in Alameda County. So, unlike Lucero L, which didn't have a lot of facts, In Re IC has a ton of facts, so I'm going to be going over those. So, 2 months before the dependency court petition was filed, IC was uncontrovertedly sexually abused by the neighbor, Oscar. This abuse consisted of at least kissing on the mouth and possible digital penetration with a toy train and possible sex. JC says that Oscar, they were all playing and Oscar told him to look away, but JC didn't look away and he saw Oscar putting the toy train in IC's vagina. IC says a whole bunch of stuff. There was a medical examination that occurred at the ER and it was inconclusive regarding whether or not there was penetration. 2 weeks prior to the dependency court petition being filed, IC was going to school with her brother and unexpectedly ran into Oscar. This occurred on a Friday. Fast forward a few days, Tuesday, IC spontaneously says to her mom, "My dad put his penis in me." Mom's like, "No, that's what Oscar did to you." And IC's like, "No, that's what my dad did to me." And Mom's like, "No, you're confused. This happened with Oscar." And IC is like, "Nope, it was my dad. And it happened here on the bed." Mom tries to press IC for more details and is unable to get anything else out of her. The quote from Mom is that it seemed like IC's statements didn't go well together and it didn't make very much sense. So then we fast forward, DCFS gets involved, they file the petition. According to the social worker, in the report she wrote that IC was not able to tell the difference between a truth and a lie. So light bulb should be going off in your head. Truth and competency, Lucero L. IC participated in a sexual assault forensic exam. The results of that exam were inconclusive. IC also participated in a forensic interview. In the forensic interview, this was a videotaped interview, and the videotape was actually admitted at the trial. In the forensic interview, she promised that she would only tell the truth and no lies. She said that her father sexually abused her. And these are kind of details of all of the various statements that she made in this forensic interview. And she's young. She's only 3, but she's extremely verbal. She says, I told Daddy put penis on me, then he put a train on me, then he put a flower on me yesterday. You know, she says things like, I don't wear clothes, he'd take off my clothes, he'd take off my shoes, my pants, my shirt, my underwear too, and my socks. And, you know, these are pretty specific statements. She said that she was on the bed, her father was lying next to her with no clothes on. Father smacked the wall 5 times. IC said, stop it. She got up and ran away and went to the garage, quote, because he did stuff to me and I'm sad. So these are all super specific statements with a lot of details considering the fact that she's only 3 years old. She did indicate to the interviewer that the penis is the same thing as a train. She said that the abuse took place both in her house and also on the mat that she was sitting on during the interview. So clearly some of the things that she was saying are just not physically possible. The dad didn't abuse her on this mat where she's having her forensic interview. She also said that her father sexually abused RJ in front of IC, in front of IC's babysitter, and the babysitter's daughter. So we get to the trial. Social worker testifies that IC is very, very intelligent, is very, very mature, beyond the age of 3. She has a very high level of language development, which I think is pretty clear from her statements in the prior pages. The social worker testified that she believed the disclosures, the child reported the same things to the mom, the daycare employees, the social worker who interviewed her, and the forensic interviewer. She gave them all the same account of sex abuse by the dad. And then RJ, who was allegedly also abused, according to IC, testified that her dad had never touched her inappropriately and she'd never seen the dad touch IC inappropriately. So the trial court clearly struggled in its ruling. It really went back and forth and was like, well, there's evidence over here to say that these statements are reliable, but there's evidence over here to say they aren't reliable. The court did end up sustaining the petition. There was no corroborating evidence. This is based solely on IC's statements of abuse. Court of Appeal affirmed the trial court's ruling and just completely deferred to the trial court. And then the decision is appealed to the California Supreme Court, and that's the decision that was issued earlier this year in 2018. The father on appeal did not challenge the admissibility of IC's statements. He was like we talked about earlier, they're coming in. We can't keep them out unless they're the product of fraud, undue influence, or deceit. What the dad was arguing was that the juvenile court misapplied Lucero out when it relied solely on IC's statements in finding that the abuse occurred because the indicia of reliability requirement is not met in this case. So then we get to the Supreme Court review. I'm melting, you guys, I'm sorry. It has, quite honestly, it lays out a child hearsay exception beautifully. It's so eloquent. It's so much better than I could ever lay it out to you in these slides. So go read In Re IC. The standard of review on appeal, the Supreme Court said that in light of the record as a whole, was there substantial evidence to support the determination that the child's statements bear this indicia of reliability? The court says that a court cannot conclude that the standard is satisfied merely because the record contains some evidence that the court could have found reliable. It's kind of hard to tell with this font, but that could have is italicized, and that's italicized by the Supreme Court. That's not italicized by me. So they're saying that we have to look at the record as a whole, and looking at everything, is there substantial evidence to support it? Not is there some evidence that the court could have relied on. And in Re IC, in the opinion, the court held that the The liability requirement espoused by Lucero L. is not designed to be so stringent that it will impede the government's ability to protect children in an abusive situation. However, neither is it an empty formality. To me, that's extremely important because that is the Supreme Court saying, this isn't just a rubber stamp. Yes, indicia of reliability, indicia of reliability, indicia of reliability. No, you actually have to analyze each case independently. Especially in the context of Lucero L, where the central issue concerns the very reliability of the evidence on which the court based its findings, i.e., is this child telling the truth or not about this alleged sex abuse? So we get to indicia of reliability again. And the court goes into a lot of detail in re IC, it's really hard to say, and it goes through all of these factors. So we go back to the Lucero L factors. Spontaneity, consistent repetition. The Supreme Court said that this child's statements actually weren't spontaneous because the child made the statement about the abuse by her father a handful of days after she was re-traumatized by unexpectedly seeing her actual known sex abuse perpetrator. So it's not really spontaneous. The court said that you can't rely on the consistent repetition here either because she kept repeating things that didn't make sense, such as a train is the same thing as a penis, or things that weren't true, that the father abused RJ, for example. Second, the mental state of the declarant. The Supreme Court noted that IC interwove fantasy and reality. So in her interview with the forensic examiner, she told the forensic examiner, you know, I spent the morning taking a nap with my babysitter, I drove into San Francisco with my mom, I watched a movie, I went to the park. Okay, great, all of this sounds fantastic, except for the fact that none of those things actually happened. So the court is saying she interweaves fantasy with reality, so there's some weird mental state issue going on here. She really doesn't know what she's saying, and we can't determine what's true versus what's not true. For use of terminology unexpected for a child of similar age, when she disclosed the sex abuse, alleged sex abuse, by her father, she used the word penis. She didn't use that word in her initial disclosure with Oscar. However, Mom testified at the trial that after the incident with Oscar, she had extensive conversations with IC regarding sex abuse and what's a safe touch and what's not a safe touch, and Mom used the words penis and vagina. So the court's like, okay, well that's where this random use of the term penis came from. 4 is the lack of motive to fabricate. So the court said here there's no evidence there's a motive to fabricate, but again it goes back to 2. The child does clearly interweave fantasy and reality. 5, truth and competency is a factor but not dispositive. Interestingly, in a footnote in the In Re IC opinion, the Supreme Court indicates that for the very first time, at oral argument for the California Supreme Court, DCFS is like, oh, actually, Lucero L doesn't even apply because there's no proof that this child was truth incompetent. I don't know what the heck that person was talking about because in their own reports, in the DCFS report, it said that the child couldn't distinguish between a truth and a lie. I don't know why they're making that argument. But there are 2 lessons here. Number 1, truth and competency is a threshold issue for Lucero L indicia of reliability. And number 2, forfeiture of arguments. Supreme Court was like, haha, nice try DCFS, not even going to entertain that, you totally waived that by not bringing it up down below. And then 6 is anything else. So here, DCFS argued to give a lot of weight to that social worker's testimony. You know, the parties stipulated that she was an expert in risk assessment for child abuse and child sexual abuse. She testified that the child was very credible, believed the child's disclosures. Court says, no, nice try. We aren't really going to consider that because that social worker that testified didn't even interview IC directly. She just read everything else and watched the forensic interview, so we don't really care what her opinion is. DCFS then argues, oh, okay, so about that videotape that social worker watched, we need to give that a lot of weight The trial court gave it a lot of weight. The trial court said so. The appellate court gave it a lot of weight because the trial court gave it a lot of weight. And maybe the trial court's determination of indicia of reliability rested on that evaluation of IC's credibility based on what was in that video. The court says, again, no, nice try, not happening. We need to review and weigh the entire record as a whole, not just one piece of it, to see whether or not the juvenile court's finding is supported by substantial evidence. And guess what, you guys? It's not. It was overturned. So contrary to everything I've been telling you this entire presentation, we actually have a sex abuse case that we like. That's good for us. So we like IC. The court says, given all of the factors, the indicia of reliability, all of the evidence, there is not substantial evidence to support the indicia of reliability as required by Lucero L. The Supreme Court said that, number one, trial court made a jurisdictional finding based entirely on the trial's hearsay statement. Number two, trial court did not make an express finding that there were indicia of reliability. And number three, based on the record as a whole, there was no basis to support an implied finding of indicia of reliability as required by Lucero L. So interestingly, even though they were kind of applying Lucero L at the trial court level in Re IC, it wasn't explicit. The court never said, I am analyzing these factors and I am making this finding. It was all just kind of an implied process. So, what does all of this mean? Truth and competent minor, those hearsay statements are coming in. However, they cannot be the sole basis of jurisdiction absent the Lucero L indicia of reliability. The threshold issue here is establishing the trial is truth incompetent. So whether that's in the reports, whether that means calling the child to the stand and trying to qualify them, we have to establish that the child is truth incompetent. IC teaches us that these cases are fact-based. They are super specific. And in the opinion in IC, it does even say that this is a very unique circumstance, because in IC you have a child who was for sure sexually abused by this neighbor, and then 2 weeks after that makes these disclosures about dad. That's a very unique situation. But it teaches us that these cases are 100% fact-based. We need to argue the facts, argue that the indicia of reliability are not present. For those of you that came to my last training on this issue, Lucero L, I told you yes, she's lying, and yes, it matters. And In Re IC is the perfect example of that. It's not over, don't worry. Does anybody have any questions? Yes.
If in the report the social worker states that the child is not truthfully competent, but you have reasons to suspect, can you just overcome that by putting them on the stand?
Yeah, I would call that child and qualify them or not, because you 100% have to establish that first. Any other questions? Yeah.
Is this a pre-trial issue? Like, it sounds like it's an admissibility issue, so it's something you want to handle pre-trial, or is it something that, I know in the cases it seems to be fleshed out in the actual trial,
Yeah.
but I do think she would be handling this as like a evidentiary hearing separate and apart from the trial.
I would probably ask for an evidentiary hearing prior to the trial beginning, because it all rests on whether or not this child is truth incompetent or not. But it's interesting because you're right. In the case law, it all comes out at trial. And it actually, in the case law, is super messy.
Yeah.
Like I said, in Re IC, they don't even come out and actually argue Lucero L at the trial court level. It's all just kind of implied and nobody says it. So I think having that separate hearing beforehand can help clarify the record and clarify the issues. Yeah.
Wouldn't you do it as a 350C once the department rests? They usually just put their reports in.
Yeah,
That would be
you
the
could.
point.
Yeah, absolutely. And then if not, proceed with your trial. Yeah. Any other questions? Okay. I'm really excited to not have to stand up here and talk under these lights anymore. So first, before I get into our game, I just want to plug the training committee's Survey Monkey survey. If you haven't yet completed it, please do that. Jasmine sent out an email. If you just search like MCLE FAQ, there's a link to Survey Monkey in there. If you guys could all please provide us with feedback on these trainings, it would be super helpful. So moving into our game. I'm going to give you guys a couple minutes. We're going to do this online. Never done it before. Hopefully our technology cooperates. Where's John? Did John abandon me? Okay. Well, hopefully I can do it. So form teams of 5. So form teams of 5. Come up with a group name. One person per team is going to get out your phone. You're going to go to this website.
Go to the website?
Yes. Hood.it.
What's the code?
What's the name of the
Only one person will do it.
Okay. Well, do you have it up ready?
I've got it.
the hood it?
Welcome back. Oh wow.
Well, because it was fun and all, and I loved seeing the JFK Presidential Library, but it was also 5 days with people who were undocumented and living their life. I thought I was a pretty sensitive person to this stuff because, you know, I do this for a living. But yeah, no, it's like every time you get in the car, every time, I mean, it's just constant worry from all day long.
Wow.
Yeah, and it was, and then plus, you know, I told you about Stephanie's ankle off. So my boyfriend's niece came up from Guatemala and had a coyote, except they had to walk for 50 miles at one point through the desert.
Wow.
And she broke her ankle. And they could have, normally they would just have abandoned that person because that person is now stranded.
Yeah.
They got her all the way to the border.
Wow.
And then put her in a phone booth and called the authorities. And, but then they gave her, of course, minimal medical care and just put like 7 screws in her foot, and now she's going to have a limp for the rest of her life. She's 20. But the good news was, the reason why she came here was to
Log
be
in,
with
you
her
guys are
love.
going to get the pin, you're going to enter it, make sure you come up with your team name. Answer the questions.
Coyotes.
It's multiple choice. If you answer correctly, you get points. If you answer correctly and quickly, you get more points. If you answer all of them correctly in a row, you get even more. And
Dennis.
whoever wins
Yeah, we need
gets
the
the
codes.
prize. So you can 1 second.
Because, you know, we shepherd people through the desert, right? We shepherd people through the desert of dependency.
A metaphorical desert.
Yeah. Team mode. Team mode.
Oh, do we have to download the app?
No.
That's the pin.
go.
That's the pin.
Good code.
What's the pin?
There's your pin. So enter your pin, enter your team name,
2025.
and hopefully we'll all get up there.
Nickname, Coyotes.
Nickname.
Okay, go.
Let's play.
You're in. See your nickname on the screen? You see? Yeah, there we are.
Okay, hey, come on.
I understand. What are we supposed to be doing?
Questions. Yeah, questions.
We need to answer the question.
Well, he's saying, come on, like I'm supposed to be doing
Oh,
something.
is it not giving us questions yet?
No, no.
Oh,
the
she has
questions
to
come on
press
the
start.
Alright, is everyone in?
Ready for a nap.
We aren't missing anyone. If you aren't in, you don't get to win the prize. So everyone's in. Alright,
Team 5.
so the questions are timed. So make sure you answer before you run out of time.
Deep ups. Seven
Yes,
questions.
7
yeah.
questions. What should you do when you get on the
The answers are going to appear in a minute.
Oh.
What should you do when you get a Lucero-Alpha pattern?
Maybe the shell there.
Yeah.
Neither or
Triangle, triangle. Yes.
okay, I think it's arguing.
I'm hitting.
You should already, yeah.
5 seconds.
I don't know, maybe arguing you should. We'll see.
Well, we already pressed the.
Yeah, that's fine.
Alright, everyone got it right. Do any of these, just don't cry.
Everybody got it right?
Yeah, because, I mean, those three apply.
Alright, ready for a nap is in the lead. Next question.
They're really ready for that. The first one.
California Street.
That's the Cicero.
Sorry, I just knew it.
Did you press US?
No, California.
Yeah, I'm like, the circle.
Did you for the color and did you for the color there too? Orange and shit?
Oh, yeah.
Okay, California Supreme Court case. Not U.S. Supreme Court, California.
I meant to get that one.
Up, middle two, over the head.
We're in the two.
We went from 5th to 2nd.
Yeah.
So which one is not?
Were you too fast?
Age of the child. Age of the child.
We already we did this 30 seconds ago.
Did you get it? Yeah.
Oh wow. You gotta wait till 30 seconds.
That's a lot of time though. I mean, at least I said mine in 5 seconds.
Oh, there it is.
And it's a matter of who got it quicker.
Quickest and
Age is not a factor. It's something to consider because obviously a younger child is more likely to be treated competent, but it's
Get
not
back to
a
the
factor.
game.
Alright, little champ still in the lead. Uh-oh, Coyotes are real close. 2 points apart. Alright.
Oh, wait.
what is
It's a Cindy. Cindy L. Yeah. Well, wasn't it comment old? Like, didn't she say something before Cindy L? Didn't she say there was an older case before Cindy L?
Carmen? Oh.
Comment old.
Oh my gosh, you guys!
It was comment old. Remember, she said something came out before.
That was a middle chance.
Great question. It was Carmelo. I didn't include that in the slides, but I talked about it.
She talked about it.
So someone got it right.
I'm doing first. I'm doing first. Orange. I'm doing first.
Is it unavailability to testify?
No, because remember at the age, I think it's fine.
Most of you got it.
All right.
Only time the statements are excluded from evidence under WIC 355 is if we can show they're the product of undue influence, deceit, deception. That's the only time. Even if Lucero, Allen, issue of reliability are met, they're still coming into evidence. Oh, coyotes.
Wow.
Yay!
Alright, 2 more questions. Second to last question. When do you use Lucero L?
Circle.
Circle. Did you already click?
Yes, so when you have a truth incompetent child, that is when you use the zero out. When you're trying to prevent statements from coming in, that's when you have to go back to like 355, fraud, undue influence, deceit. Okay. I think we have one more question, right?
One more question. Finish line. Yes. Hey.
I like that.
I promise I won't be offended.
No, yeah.
Alright, yay! No problem.
Everybody got that right.
Alright, let's see what. Oh, a defender!
What the fuck? We got everything right, and then you couldn't say definitely yes fast enough. Is that what it is?
This Kahoot.